Recording 8.1, Unit 8, The Differences Between Civil Law and Criminal Law. How do you distinguish between civil and criminal legal issues? What are the differences between a civil case and a criminal case? Crime is usually characterized as a public interest issue because it involves a concern for society. The public interest includes protecting citizens against being robbed or assaulted. Criminal law covers these types of legal problems. Its purpose is to punish and rehabilitate offenders while protecting society from harm. Because the public has an interest in criminal law, we give the government the authority to implement and enforce it. The criminal law is enforced by police and crown prosecutors employed by the government. These services are funded by public funds. If you are a victim of a crime, you should report it to the police who are responsible for investigating it. As a result, they arrest and charge the suspect. When charges have been properly laid and if there is evidence to support them, the Crown Prosecutor, not the complainant, prosecutes the case in court. The system is known as public prosecution. There is still the option of prosecuting privately, but it is rarely used nowadays. The Attorney General has the authority to take over a prosecution that has been started privately. You do not need to enforce the law on behalf of the victim. Not for yourself, but for the public at large, the police, and the Crown Prosecutor are there to serve. Crown prosecutors in criminal cases must prove that the defendant is guilty, beyond a reasonable doubt. This means that after a trial the jury or judge can only find the defendant guilty if they are not left in any doubt about the defendant's guilt. This means that there is no logical or rational basis to question the defendant's guilt. A civil law case would not work like this. It deals with private disputes between individuals or between individuals and organizations. Civil law includes areas such as contract law, family law, tort law, property law, and labor law. To prove a case, a plaintiff needs to provide evidence that a judge or jury believes more than the defendant. The plaintiff must prove his or her claims on a balance of probabilities. They don't need to be convinced beyond a reasonable doubt.
The Attorney General has the authority to take over the prosecution that has been started privately. Not for yourself, but for the public and the Crown Prosecutor are there to solve. Guilty is they are not listed in any doubts about the defendant.